So thank you again for the invitation. For me, it's a real pleasure to be here. I'm so sorry that today I can meet you only with the digital instrument, and I really hope that next time we can meet again all together, like in the past. Let's see and let's talk about penal evidence in the tax process. I want to talk about this specific subject because in Italy, we are in the last year adopting a strange approach, let me say, and I want to talk with you about this. So before, I want to make a short introduction about the dual track system, a system that we are adopted in Italy. And it must be noticed that Italy adopts this kind of system to enforcement to deal with the tax offenses. Some offenses are administrative offenses, penalized through administrative law and the sanction therein. Other are criminal offenses. Those are penalized and or punished through criminal sanction. So in Italy, we have two autonomous sanction systems. This implies that in accordance with Article 20 of the legislative decree number 74 of the 2000, the penal judgment does not affect the tax trial and the two proceedings run in parallel. In accordance with Article 479 of the Criminal Procedure Code, the criminal trial cannot be suspended pending the definition of the tax one. This system, as you can understand, can create some practical problems because, in other words, sometimes we punish the same conduct with administrative and criminal sanction. The doctrine has long highlighted the critical points of this dual track sanction system, especially with respect to the double jeopardy principle. But the Supreme Court, with the decision number 4439 of this year, but this is one of the last because we have several decisions in this sense, ruled that in case of tax crime, there is no nebis in idem. So the double track system is justified by the importance of national financial interest. Administrative procedure is aimed at recovering unpaid taxes, and criminal procedure is aimed at preventing and prosecuting tax offenses. So after this short presentation about the dual track system, let's see the evidence in the tax litigation. So Italian tax litigation is based on a civil law system and therefore solely on written sources. Generally, the decision in tax litigation is based only on the documentation provided for by the parties. Consequently, written testimony is not allowed. Third-party written statement, as well as information collected from third-party, can be used to corroborate the party's position. So they are considered like indirect evidence. And such indirect evidence can be used in judicial decision so long as they are not the sole base for the decision. The hearing is generally private in our system without parties attending, but legislative decree number 546 of the 1992 provides the right to request a public hearing up to 10 days before the scheduled hearing, in which the parties can explain their defenses to the tax court. If the party failed to attend, the litigation still takes place. Each party is entitled to file before the tax court any document considered useful for the case. There are no specific disclosure obligation under the Italian tax law. The judges have the right to ask to the parties for any additional documentation they consider useful to solve the case. the tax judge may request access to inspections, data, information, technical reports for public administration advice. In both in civil and criminal tax litigation, the burden of proof rests with the public authority. Let's see now the criminal proceeding. So a proceeding that is totally different about the previous proceeding, the tax proceeding. So evidence have been one of the most issues which the reform of Italian criminal justice system has taught with more effectiveness. It is worth noting that the code dedicates an entire book on evidences, the third books, which represents an actual microsystem, we can say. The book number 3 is divided in 3 titles, respectively dealing with the general principle, the single means of evidence, and the means of obtaining evidence. With reference to the first title, I mean, in relation with the principle, it is not mentioning that the code entrusts the parties with evidentiary power in all the stage of the fact-finding process. With regard with the search of the sources of evidence, the Italian system recognizes to the public and private parties wide investigative powers. With regard to the phase of admission of evidence, the Article 190 of our code states that evidence shall be admitted upon request of the party. The judge shall decide without delay by issuing an order excluding any evidence that is not allowed by law. Public prosecutor and judicial police, in the context of their respective duties, of course, carry out the investigation deemed necessary for the determination inherent in exercise of the criminal action. In accordance with the provision of the Article 329 of our Criminal Procedural Code, preliminary investigation documentation are kept under secret until the suspect can become aware of it, and in any case, no later than the closure of the preliminary investigation. In order to create, and this is important, a solid barrier between investigation and trial, the Italian code established a double dossier system. On conclusion of the preliminary hearing with the committal to trial, 2 dossiers are created. In one hand, the trial dossier is formed, which contain only the documentation that are strictly provided by the code, and it is mainly evidence that is in ab origine impossible to reproduce in the court, like, for example, interception of communication or crime science analysis and so on. On the other hand, the investigative dossier is created, which contain all the documents referring to action carried out during the preliminary phase that are not filed in the first dossier. The judge does not have access to the investigative dossier, and the parties cannot take the initiative of reading at the trial any prior statements or other investigative records included in this dossier. The evidence in general taken during the trial, but also in the previous phase, must be lawful gathered. And this is an important principle, of course, and is a principle that is stated in a specific article in our code. I mean, the Article 191 that established that evidence gathered in violence of the prohibitions set by law shall not be used. This is one, as I said, one of the most important articles, according to me, and is also one of the most important innovations of this Italian evidentiary system, which aim at guaranteeing the principle of legality in evidence gathering. But, and I put this question, but can we use this kind of evidence that is not legal, let me say, because they don't respect the criminal code, the criminal procedure code, can be used in another trial, in another context, let me say, and that this is something particular, let me say. Why? Because in Italy, honestly, we can use this illegitimately, let me say, criminal evidence, and where we can use in the tax litigation. The court, with the decision 32,185 of the 2019, and also with another ordinance of the last year, but we have also in this case a lot of sentences, a lot of decision in this sense, confirm the usability of the evidence assumed in the context of criminal proceedings, also in the parallel tax proceeding, pointing out that this will not assume in the tax context equal probative value, but only circumstantial forces. At the same time, and this is particular, let me say, but I would like to use another word, they also go so far as to sustain the equal usability of the evidence that are illegally assumed, given the autonomy of the two proceedings. So, in other words, tax litigations in Italy may also arise from illegal evidence. The intent of the Supreme jurisprudence is not to waste investigative effort and cost. And according to them, this can be possible because, as we said, we have two autonomous systems, the dual track system that we mentioned at the beginning, and also because in the tax system, we don't have a specific article like the 191 that we mentioned a few minutes ago that consider not useful the evidence that are against the law. So this approach, in my opinion, runs counter to the taxpayer rights, fundamental rights, and also is against the constitutional rights. So I don't agree. The jurisprudence of the last years, and honestly, I'm not the only one in this state that don't consider available this kind of approach, but this is, so we hope that in the future, probably the Supreme Court will change idea and we will see the evolution of the jurisprudence in Italy. At the moment, this is the situation. So to protect the financial interest, especially the national financial interest, we adopt particular, or we interpreted in a particular way the law. And this is what happened in Italy. I don't want to take the floor for a long time. I'm so happy, as I told you, that I had the opportunity, even the trouble of the vaccination of the day, to share with you this information. And what can I say? Thanks for your attention.